We'll continue now with Fiona Spencer's paper on a few recent cases and how proportionate liability operates in practice. And we'll have questions to both Matthew and Fiona at the end. Fiona was a senior associate with Blake Dawson's Litigation and Dispute Resolution Group, and she, in that role, handled a number of diverse cases and in different jurisdictions. And she has probably concentrated at the bar on administrative law more than other areas, but you will see from the pack that you have with her bio in it that she does handle a vast area of litigation. So without more ado, I'll hand over to Fiona.
Thanks, David. The first two cases I'll be discussing today really deal with different aspects of the question of who is a concurrent wrongdoer. And then the next case that I'll be discussing after that is a very interesting case. It raises a number of issues where you have either multiple proceedings against concurrent wrongdoers or where there is a settlement between the plaintiff and one or more concurrent wrongdoers, and the effect that that then has if the proceedings are on foot, remain on foot against other concurrent wrongdoers. The first case I'm discussing is Mitchell Morgan. It's a case of the full New South Wales Court of Appeal, and it really dealt with the question of who is a concurrent wrongdoer in this context. Mr Caradonna and another man, Mr Vella, decided to enter into a joint venture around $300,000 in relation to a boxing fight between Anthony Mundine and Danny Green. Now, they got the money and they borrowed that from a mate, and then they thought that they might go and use that money to consolidate some loans on some properties of Mr Caradonna. That didn't go ahead, but Mr Caradonna obtained the certificates of title for those properties in the course of those interactions. And then he used them with Mr Flamier to procure a fraudulent mortgage from Mitchell Morgan. Mitchell Morgan paid them over $1 million. And in the context of this transaction, Hunt and Hunt were Mitchell Morgan's lawyers. And they failed to use an appropriate form of mortgage in order to ensure that Mitchell Morgan got appropriate security over Mr Caradonna's properties to secure that loan of $1 million. So the question that was on appeal before the New South Wales Court of Appeal really was whether or not Mr Caradonna and Mr Flamier were concurrent wrongdoers with Hunt and Hunt. Mitchell Morgan on appeal argued that Hunt and Hunt wasn't a concurrent wrongdoer because the loss and damage that Hunt and Hunt caused was different to the loss and damage that Mr Caradonna and Mr Flamier caused. And presumably why this occurred is because Mr Caradonna and Mr Flamier probably couldn't pay up for their 72.5% and 15% that they were deemed responsible in the first proceedings, and Mitchell Morgan wanted to see if it could come after the deeper pockets of Hunt and Hunt and find them joint and severally liable as opposed to only 12.5% liable. Now the question that the Court of Appeal dealt with is what is the damage? And the issue that was discussed is that you can look at the question of what is the damage at two levels. One, you could look at it at a very general level and you could say, oh well, Mitchell Morgan's lost money. And both Hunt and Hunt and Mr Flamier and Mr Caradonna contributed to that general result. But the Court of Appeal said that's not right. It said just because two or more wrongs lead to the same result does not of itself mean that the wrongdoers are liable in respect of the same damage. Looking at it at that general level is not correct. You have to look at it at a far more specific level to see whether, in fact, the loss and damage was the same. And when the Court of Appeal looked at it at this more specific level, they found that there were two different losses here. They found the loss that was caused by Mr Caradonna and Mr Flamier to Mitchell Morgan was paying out the money on the loan when they would not otherwise have done so. But the loss that was caused to Mitchell Morgan by Hunt and Hunt was not having the benefit of the security over the property of Mr Caradonna so that they couldn't recover the loan. So there were two different losses, two different sources of damage. And the Court of Appeal really relied heavily on the Victorian decision of Quinnertz, which Matthew's already discussed, and said one of the ways to see whether or not the damage is different is to see whether the damages that flow from the damage are different. And this is a good example of that, because the damages that flowed from the loss caused by Mr Caradonna and Flamier was the amount that Mitchell Morgan paid out on the loan, so the over $1 million. But the damages that flowed from Hunt and Hunt's negligence was simply the lost value of that security. And they could be very different things. If the loan was only secured, say, for $500,000, well, the damages that could be awarded against Hunt and Hunt would be less than the $1 million that would be the damages that could be awarded against Mr Caradonna and Mr Flamier. So that's how the Court of Appeal reinforced its finding that the loss here was different. I'll just mention very quickly, there's another interesting decision in the Victorian jurisdiction on this issue, which I won't discuss today, but if anyone's interested in this area, it's Ashbrook Institute Proprietary Limited, Bartone Biomedical Proprietary Limited. It's the medium neutral citation is 2010 VSC 579. The next case I'll be discussing, which deals with an entirely different aspect of who is a concurrent wrongdoer, is one of the interlocutory decisions in one of the bushfires class actions, so Matthews and SPI Electricity. And essentially in this proceeding, 4 of the defendants are relying on proportionate liability defences. But the question that was before the court in this interlocutory decision was that the Utility Services Corporation sought to amend its defences to plead that SPI Electricity was liable for the negligent acts and omissions of the State Electricity Commission and Electricity Services Victoria. And they were the bodies, the predecessor bodies to SPI Electricity. And when SPI Electricity was set up, it acquired the liabilities of the SEC and the ESV. And so the question that was before the court was SPI, because it acquired these liabilities from the predecessor bodies, a concurrent wrongdoer in respect of those liabilities within the meaning of the Wrongs Act? So put another way, can someone be a concurrent wrongdoer based on derivative liability as opposed to their own conduct? Now, the Act provides that a concurrent wrongdoer is a person whose acts or omissions caused the loss or damage. And the court relied on the very plain wording of that provision to say that no, you can't be a concurrent wrongdoer based on derivative liability. Your actions or omissions must in fact be a cause of the loss and damage. You can't rely on the actions of third parties to impute to another person liability for the purpose of proportionate liability provisions. And as well as the plain language of the statute, another 2 authorities that His Honour Justice Forrest relied on were UCAC, Avanti Developments, and Perpetual Trustees and Paladin, which are also interesting decisions in this area. A matter that really reinforced His Honour Justice Forrest's decision in this area was that the South Australian legislation specifically provides that a concurrent wrongdoer includes a person who has derivative liability. And of course the Victorian Act certainly doesn't do that, and there was a contrast drawn by His Honour Justice Forrest in that regard. The next case I'll talk about is a very interesting, very recent case of the New South Wales Supreme Court, Burns and Ingram. Now, this case concerned a syndicate of all these people that are listed there on the slide, and they all were going into to do a restaurant business. And Mr. Burns there in the middle invested $3.5 million in it, and then the restaurant business failed. So Mr. Burns decided to try and recover that money. And the first person that he sued was Mr. Grevler. Why? Well, Mr. Grevler was a chartered accountant for the syndicate, so Mr. Grevler was insured. So Mr. Burns proceeded against Mr. Grevler and claimed the entire amount of Mr. Burns' loss and damage. Mr. Grevler was found liable for 100% of the loss and damage, and Mr. Grevler didn't raise proportionate liability, didn't raise it in his defence. So then Mr. Grevler's insurer paid out, but was unable, for whatever reason, the insurance amount that was paid out didn't entirely compensate Mr. Burns in respect of the judgment that was awarded against Mr. Grevler. So there was a shortfall of about $300,000 odd. Now the question that then arose was that Mr. Burns decided that he would sue Ingram 1, one of the other members of the syndicate. And Ingram 1 tried to get that proceeding dismissed as an abusive process. And one of the questions that arose was the question of Anshin and Stoppel, of course, and I won't go into that today, but when the court was discussing the broader aspects of whether or not this proceeding was an abusive process, the relevant provisions of the proportionate liability regime were relied on by both parties to argue that on the case of Burns that it wasn't an abusive process, in the case of Ingram 1 that it was. Ingram essentially said that if Grevler was a concurrent wrongdoer, then Grevler was found 100% responsible. And then therefore the proceeding would be an abusive process because what Burns would be trying to do by suing Ingram 1 would be to change the comparative responsibility for her loss from 100% to, who knows, 20, 80, whatever. And that would be an abusive process because it would lead to inconsistent judgments. Ingram said it was also abusive because it was doomed to fail. Grevler was found 100% responsible. And also said that it was an abusive process because Ingram was denied the benefit of the proportionate liability regime. And there are a number of components to this, and I'll try to explain it using the Victorian legislation, even though there are some differences which I'll explain. So the first matter that Ingram raised is to say why it was unfair for the proceeding to proceed against her was that the court could not apportion responsibility in the proceeding against her because the court was only permitted to apportion responsibility between defendants in the proceeding. And the problem with that is that because there'd been a judgment against Grevler, Ingram couldn't join Grevler to the proceeding. So you're left with a situation where Burns will sue Ingram, but Ingram's unable to join Grevler, therefore unable to apportion Ingram's liability between Ingram and Grevler in the way that Ingram would have been able to do if Ingram had been sued at the same time as Grevler. Now, I should mention that this argument, in my opinion, was incorrect in the New South Wales context, although it is incorrect for the Victorian context, the reason being, of course, that in New South Wales it's not a requirement that a defendant be joined for the court to take into account the liability of that defendant, whereas it is a requirement in Victoria. So the argument as put in New South Wales, in my opinion, was incorrect in New South Wales, but it is correct in Victoria. And the next thing that Ingram said was that as well as not being able to join Grevler to try and apportion responsibility, Ingram can't go and claim contribution or indemnity against Grevler either because that's precluded. And the relevant provision in the Victorian legislation is Section 24AJ, which I've put up there. Now, Burns's answer was the New South Wales equivalent of Section 24AK. And that specifically provides for there to be multiple proceedings against concurrent wrongdoers, so that if the plaintiff is entitled to sue one concurrent wrongdoer at one time and then to proceed against other concurrent wrongdoers. It's specifically provided for. And the caveat on that, of course, is the no overcompensation provision, which I've referred to there, Section 24AK, subsection 2. That the plaintiff can't can't be overcompensated by bringing multiple proceedings. Now, Ingram's ingenious reply to this, in some ways, was that that's all very well, but the action against Grevler wasn't for an apportionable part. You see the words in bold? It was for 100%. That's not an apportionable part. This section doesn't apply. Well, the court disagreed, unsurprisingly, and said that the New South Wales equivalent of Section 24AK expressly contemplates multiple actions, and that there's a real public policy interest in plaintiffs being able to sue who they want, when they want. And that makes sense, because really it wasn't Burns's fault that Grevler failed to raise this defence, it was Grevler's fault. And that if that defence had been raised, then the defendants would have had the benefit of that at that time. And it also seems to be a fair decision, because Ingram won't in the end be prejudiced because of the no overcompensation provision and the prohibition at common law on parties recovering more than 100% of their loss. So really the party who's going to miss out in this situation is Mr Grevler, because likely he would have been found only proportionately liable, but he, or his insurer in this case, stumped up over 90% in the end of Ms Burns' loss. So this is an example of what can occur when you don't raise a proportionate liability defence. It causes big problems for the party who didn't raise it when they ought to have raised it. Mr Grevler now, he's in a bit of trouble. He's stuck with his 90-odd% that he's paid out. And Ms Ingram has had some issues in trying to ensure that her interests are protected. Now, just going back one slide, while the court seemed to accept that contribution and indemnity couldn't be claimed between Ingram and Grevler, in my opinion there's a live question about that because of the words that I've highlighted in bold, in the same proceeding. So there's a prohibition on defendants in the same proceeding claiming indemnity and contribution against each other. But of course this wasn't the same, these were two separate proceedings, not the same proceeding. So you've got to wonder whether in fact the ability to claim contribution or indemnity wouldn't have been extinguished by this provision, and that either Mr Grevler or Ms Ingram could have made claims in that regard against each other because they were separate proceedings. That's just a little thought. Now that decision, while it didn't deal with settlement, leads on, in my opinion, to settlement because it raises a number of the same types of issues that occur when you have got a settlement, and the same provisions that I ran through before, the provisions that in the Wrongs Act that really are enlivened when you're dealing with issues of settlement. So the concerns of the proportionate liability regime that are commonly expressed include difficulties with the practical application of the provisions, but more often the impacts that it has on the cost and disposition of cases. And nowhere is this seen more starkly, in my opinion, than with settlement. Two of the big questions that arise in this area are on the screen, and I'll try to discuss where the cases have come down on those issues now. And this is by reference to a couple of older cases, which I think are necessary in order to set a framework for some of the more recent decisions in this area. The first decision, very important decision in this area, is Gunston and Lawley. In this case, it was a building case, which is so commonly where this issue arises, and the owner sued the builder, the surveyor and the draftsman. Now, before the proceedings, or in the course of the proceedings I should say, the builder settled for $100,000 with the owner and the surveyor settled for $65,000 with the owner. But they remained parties to the proceeding, and the court nevertheless apportioned liability between all the parties. And you can see that the way that the court apportioned liability differed from the way that the parties had settled the matter. And so the party that was left was Mr. Draftsman, and Mr. Draftsman said, well, hang on a minute, you found me 16% liable, $41,000, but my liability ought to be reduced because Mr. Surveyor stumped up much more than he was liable for, and that should be taken into account in my benefit. And that, of course, is what occurs under joint and several liability. If the plaintiff receives a settlement from one of the defendants which is favourable, then that amount will be taken to reduce the overall loss and damage that the plaintiff is claiming. But Justice Burns said that doesn't work with proportionate liability. You can't use a settlement that is more favourable than the actual liability of a party and take that to reduce your own liability. Your liability is your liability according to the proportionate liability regime. So that means that technically, on the face of the judgment, an owner could recover more than 100% of the loss. But where that would be potentially reconciled is with the common law prohibition on over-recovery. But that didn't fall for consideration before Justice Byrne, and as I'll take you to later, there have been a couple of decisions where it has been taken into account, but it's by no means clear on 100% certainty that that common law prohibition will come into play. And the policy reasons behind this decision of Justice Byrne were that the plaintiff bears the risk that any judgment against the individual wrongdoer will not be satisfied. That's the way the proportionate liability regimes. And it's important that the plaintiff can settle with one wrongdoer to minimise the cost of litigation. And there's a risk that after the plaintiff settles with one and that party is removed from litigation, then the other wrongdoers will establish the reverse of what occurred here, which is that party that's no longer in the litigation is actually responsible for a greater proportion than the plaintiff settled with. So everybody's bearing some risks here. And it's certainly not the case on the court's view that this is just going to benefit plaintiffs. The plaintiff has a significant risk as well when it comes to settlement. Just exploring that a little bit more. It's not, once you've settled as a party, you don't really care because you've already paid up and you've retained a release what your liability is, less for commercial perception purposes. So it's not really in your interest to try and minimise that. That leads to the draftsman, for example, being able to more easily impute more liability to the other parties to pump that up, which leads to a greater risk that the owner will have made a bad commercial settlement with the settling parties. That makes sense. Now, there was an obiter comment in a decision of Justice Hanson in McCaskill and Cavendish, Medium Mutual Citation 2008 VC 328, that Section 24AK, the provision I took you to earlier, does apply to settlements, that's the provision against overcompensation. But that's just an overcompensation. I'll just go back to that provision just quickly. So the overcompensation provision does apply to settlements, but it seems to go against the actual reading of that provision, in my view, which explicitly is contemplating multiple proceedings where there are judgments. So judgment against one, like in Burns and Ingram, judgment against Grevler, judgment against Ingram. That's where this provision seems to come into play. But I will just mention that Justice Hanson, in a bit of a throwaway line in that case, said that, look, it could apply to settlements. The next important decision in this area is, again, a building case, and the owner sued architect, contractor, engineer and surveyors. And what happened in this case is the architect settled the entire proceeding with the owner, so for 100% of the claim, on terms that enabled the architect to get the release of the surveyors, contractor and engineer. There was no actual judgment that was entered. The orders that were made in the proceeding was that the proceeding would be struck out with a right of reinstatement. So the question then was, could the architect bring contribution claims against the surveyors, contractor and engineer? And the question was whether the prohibition on bringing further proceedings once there's been a judgment was enlivened. I'll just go back to that. That's section 24AJ. It says that when you've had a judgment against a concurrent wrongdoer, you can't go and claim contribution or indemnity against that wrongdoer. But of course, there was no judgment. There was only an order that the proceeding be struck out with a right of reinstatement. And because of that, the architect was permitted to bring contribution claims against the other three defendants. And these would not be an abusive process in the circumstances of this case, given the terms in which the architect settled. He settled for 100%, but it was on terms that provided for him to get the release of the contractor, surveyors and engineer. So the court considered that indicated that he was not paying his true proportion of the loss. He was trying to settle the whole proceeding on behalf of all the defendants. So whether or not you'll be able to claim contribution in these circumstances, it seems will turn on the terms of the settlement quite precisely. If you are settling just for your proportion, it'll be an abuse of process, arguably, to then try and claim contribution for another party because you've only paid out what your proportion was. Whereas if you settle on terms like it was in this case where you're paying out more than just your proportion, you should be entitled to claim contribution. The problem with this is that the reverse is also true. The architect's not protected either by that prohibition on there being contribution or indemnity claims against it. So a settling defendant who doesn't get a judgment can have contribution or indemnity claims foreseeably from the contractor, surveyors or an engineer. Now, Justice Ashley's solution to this was that if you settle as a defendant, you should try to have a consent judgment entered for the settlement sum. And in his view, that would protect you against a contribution claim or indemnity claim from the other defendants. That was his view. Now, I will just mention that view has been doubted, unfortunately. Everyone's sort of, oh, good, that sounds good. It's been doubted in a case of Owner's Strata Plan number 62,660 and Jackson's Landing Development Proprietary Limited, 2011 New South Wales Supreme Court decision 415. And in that case, the plaintiffs settled with the defendants separately and they all entered separate consent judgments. And then one set of the defendants, settling defendants, thought that they perhaps paid a bit over the odds and tried to bring a contribution claim against another of the settling defendants. And the other settling defendant against whom contribution was claimed said, "Oh, you can't do this. There's been a judgment, and when there's been a judgment between concurrent wrongdoers, contribution claims are off." But Justice Balls doubted whether a consent judgment entered in this way would actually enliven the prohibition on claiming contribution or indemnity. In his view, a consent judgment of that nature didn't involve the findings of the court that would be necessary as to this is an apportionable claim, the defendants are concurrent wrongdoers, etc., which would be required in order to enliven the prohibition on contribution and indemnity. So that's an interesting view that he expressed. It was just an obiter comment, so this issue was still live, but it seems to cast doubt on the opinion of Ashley that a settling defendant could protect its position by entering a consent judgment. Now I just want to put a bit of a twist on the Burns of Ingram tale to see what would happen if there hadn't been a judgment with Grevler but a settlement. So let's say that Burns settled with Grevler and then Burns tried to sue Ingram 1. Then, in those circumstances, Ingram 1 could have joined Grevler because there's no prohibition on joinder because there would be no previously concluded claim or judgment against Grevler. And Ingram would have been able to join the other two Ingrams. Then what would happen in those circumstances if Grevler's liability, as found by the court, was less than what Grevler had settled for? Well, that would be tough for Grevler because Grevler could not claim contribution or indemnity against Ingram 1, 2 or 3 because there would have been a judgment against all of them in the one proceeding. So that prohibition on claiming indemnity and contribution would be enlivened and Grevler would be stuck with what Grevler had paid and wouldn't be able to readjust what he'd paid based on the findings of liability that the court found. And what if Grevler liability was more than what Grevler had settled for? Well, then still the prohibition on contribution and indemnity would apply, but now what would occur would be Burns would be out of pocket. Burns would be out of pocket. So Ingram 1, 2 and 3's liability would not be affected, but Burns had done well. Grevler had done well. Grevler got out of the proceeding for less than what Grevler ought to have paid, according to the court, and then Burns is the one who suffers because of that. Now, the last two final decisions that I mention are the two decisions that I've mentioned here, and these are recent examples of where the common law prohibition on double recovery is being considered in the broader context of proportionate liability claims. So the first case, GEJ, was an aerial spraying claim, and there were about 8 defendants that were sued, and 6 of them settled and 2 fought on. And in the end, in the facts of that case, the judge found that the claim wasn't apportionable because of a lack of evidence of the nature of the liability of the 6 defendants who had settled. So an interesting point to take away again is that where you have some defendants that settle, it makes it a lot harder for the remaining defendants to try and discharge the onus that they need to prove that the settling defendants were in fact concurrent wrongdoers. And that's what occurred here. There just was insufficient evidence for the remaining 2 defendants to get that claim over the line. Now, essentially the 2 remaining defendants just said that the judgment sum that was awarded against them should be reduced, having regard to the amount that the plaintiff settled for with the 6 settling defendants. And the court said that Section 24AK, the overcompensation prohibition, didn't apply, but that in circumstances such as this, where it was an apportionable claim, probably, even though the requirements that were necessary to make out that the 6 settling defendants were concurrent wrongdoers hadn't been satisfied, the common law prohibition on double recovery came into play, and that therefore the plaintiff wasn't entitled to recover more than the total loss and damage that it was claiming, and the amount of damages that were awarded against the remaining 2 defendants was reduced by the amount that the plaintiff had settled with the 6 other defendants. So that was some comfort to defendants in these situations. But the onus was on, so that was the case unless the plaintiff could establish that it hadn't actually received the monies. If it hadn't received the monies, the other 2 defendants would have to pay up more. The next case was TCM Builders and NICU, which is a VCAT decision of senior member Riegler. It's another building case. The owners sued a builder, architect, 3 engineers and a landscaper, and the landscaper and the engineer settled. And the question was whether those settlement sums could be taken into account in determining the liability of the builder and the architect. And essentially the tribunal found in that case that the parties were not concurrent wrongdoers because the loss and damage that was caused was separate. But in any event, the prohibition on double recovery was considered, and because essentially of the fact that they were found to be, it was found to be separate loss and damage, that wasn't taken into account. The parties were found joint and severally liable. However, certainly the tribunal indicated that had they been concurrent wrongdoers, the prohibition on double recovery at common law would have applied, and the tribunal would have taken that into account to reduce the amount of that the plaintiff could recover in this case. So that's a bit of a wrap-up of some of the most recent decisions in this area, and certainly gives rise to a lot of food for thought, a lot of issues still floating around, particularly in the area of settlement.
Thank you, Fiona. Matthew, if you'd like to come back. If there are questions, one thing that's obvious is that it's very hard to keep up to date in this area. There's so much law, and you have to look at each different jurisdiction and then consider the different legislation in each jurisdiction, which makes it doubly hard. Questions for either of our panel? No question? One question at the back.
Matthew. Toby Nolan here. The model provisions which are being considered, what status are they at, and are they likely to come in any time soon?
We don't know. The status is they're merely for discussion. In October last year, it was the due date for responses and submissions from other parties, from law firms supposedly, and other, or even the Vic Bar perhaps. I don't know what has happened in terms of looking at the responses they got from people. I would imagine it creates even as many controversies as currently exist in the current regimes. So I can't see it happening straight away, or certainly in the near future. But one of the reasons I wanted to talk about it is because it's a way that's helpful in understanding the problems we currently have as to the way SCAG want to deal with them. And they're interesting in that respect. They sort of flesh out all the problems. So they're worth looking at so that you understand the issues. So the paper they've produced talks about all the difficulties they've had and all the problems that have arisen, and they try to fix that. I don't know that they do fix it. Perhaps the best thing that might come out of it, if they get introduced, is the Victoria fits with the rest of the jurisdictions and doesn't require the joining of concurrent wrongdoers. Because at the moment it's a complete disjoint.
Any other questions? Can I just make one comment before we go, and that is one thing that nobody's covered or discussed this morning is the question of whether the legislation in whatever state you're in is substantive or procedural. And that issue is relevant if you are doing a case, suppose your contract is subject to New South Wales law and you're running it in Victoria, are you subject to the Victorian proportionate liability regime or the New South Wales proportionate liability regime? If it's substantive, you bring in the law of the contract and the substantive law, which would be the New South Wales regime. If it's only procedural, you take your procedural law wherever you are having your dispute adjudicated. It's not been decided. Nobody knows. And because of the different regimes, the consequences can be far-reaching. Okay, well, it just remains for me to thank our presenters on your behalf and to ask you to acknowledge what they've done for you in the usual way.